Yes, yes.
My Lady, my Lords, before the lunchtime adjournment, I was going to look at Proposition 5.
I think you'd better speak up a little.
My Lady, I'm so sorry. What I was going to say is that before lunch, I was about to turn to Proposition 5, which is whether the dismissal was within the range of reasonable responses.
Yes.
And my Lady, what I propose to do is to finish the rest of my submissions before coming back to the examples that I promised this morning in relation to conduct dismissals.
Thank you.
Maybe I think I can take the remainder of my submissions very quickly. Proposition 5 is that the dismissal of the appellant was within the range of reasonable responses open to the employer. Maybe I emphasise in this respect that the dismissal was both for the failure to disclose, but also for the failure to appreciate that non-disclosure was problematic. And certainly the evidence before the Employment Tribunal was that had the claimant admitted, understood that the non-disclosure was problematic, the disciplinary panel would have imposed a lesser sanction.
That's 426, isn't it? That's Mr. Griffin's evidence, which was accepted.
Well, quite so, yes. That, of course, is a question of fact for the Employment Tribunal, which can't be interfered with, save and to the extent it's an error of law. And again, I didn't understand my learned friend's submissions to suggest that that conclusion was perverse, which, of course, would be the threshold that he would need to meet. My Lady, my Lord, that concludes my submissions on issues 1 and 2. Unless you wish me to do so, I didn't propose to say anything in respect of Article 8. The matter is set out relatively fulsomely in our case, and given my learned friend's concession, I don't propose to say anything further, unless you wish me to.
It would appear not.
I'm grateful for the invitation. That then just leaves...
Well, it does raise an interesting point of law, but as it's not being raised, I think we have to leave it at that.
It certainly occupied, as you will have seen, quite a lot of our collective time. But the matter's not pursued, and therefore I won't make the submissions that I had proposed in that respect. That only leaves issue 4, which again I think can be disposed with summarily, in the sense that both of us agree that this is parasitic, as it were, on the success or failure of issues 1, 2 and 3. And the question of contributory fault is one that ought to be remitted to the Employment Tribunal should the appeal be allowed. So, my Lady, that concludes my submissions on issues 1 to 4. There just remains the sort of lingering question from this morning about examples. Mm-hmm. Over the lunchtime adjournment, I've identified 2 examples of conduct dismissal, and I emphasise, of course, that there may be other examples. The first is on your table. It's an EAT decision in Western Recovery Services and Fisher. The facts set out in paragraph 3. The respondent operates a vehicle recovery business. He permitted the employee to borrow one of the firm's minibuses to go on a fishing holiday, and on returning the vehicle, he, the employee, failed to check that it was in a safe condition, the rear step was missing and the seats were insecure. Mr. Hopkins considered this state of affairs to amount to a safety hazard and arranged for Mr. Stride, then the General Manager, to hold a disciplinary hearing. He did so, and the claimant was summarily dismissed for gross misconduct at that hearing on the 28th of November. An appeal against that sanction was dismissed in December 2008. Paragraph 4 of the EAT's decision, the first sentence, records that the tribunal treated the claim solely as one of unfair dismissal, and the judgment sets out the conclusions of the tribunal at paragraph 7. In the indented paragraph, halfway through that, the tribunal notes that it was not such conduct as should be seen as gross misconduct, justifying summary dismissal. The EAT then, attempting to unpick the tribunal's analysis at paragraph 11, say, without spelling it out, the tribunal appear to have accepted that the employer here genuinely believed on reasonable grounds, following a reasonable investigation, that the claimant was guilty of the misconduct alleged, and that the sanction of dismissal for that misconduct fell within the range of reasonable responses open to the respondent. Then asks, at the end of that paragraph, how then did the tribunal reach the conclusion that the dismissal was unfair, under presumably section 98(4). Paragraph 12, we think that the tribunal fell into error in taking the view because in their judgment, the conduct in question did not amount to gross misconduct, that is, conduct justifying summary dismissal at common law. The dismissal was statutorily unfair. Paragraph 13, the court records it's now well established at employment appeal tribunal level that the question under section 98(4) is not simply answered by deciding whether or not the employer or employee is in breach of the contract of employment. They refer to a number of other employment appeal tribunal cases, including comments of Mr. Justice Phillips in Fishman, which is a case I'll take you to in a moment. Many dismissals are unfair, although the employer is contractually entitled to dismiss. Contrariwise, some dismissals are not unfair, although the employer was not contractually entitled to dismiss the employee.
It's the converse proposition which is the more interesting.
Yeah.
First is uncontroversial.
Yes. In our judgment, this is paragraph 15, the EAT notes that on a proper analysis, applying the law to the facts as found by the employment tribunal, the present case falls into the latter category. Section 98 is, as far as material, concerned with the sufficiency of the conduct reason for dismissal. It is not concerned with the common law concept of gross misconduct, that is, conduct by the employee amounting to a repudiatory breach of the contract of employment, entitling the employer to terminate the contract without notice or pay in lieu of notice. Paragraph 16, applying section 98 as interpreted by the higher court's dismissal was fair, although they go on at paragraph 17 to find that the claim of wrongful dismissal ought to succeed because there was a finding that he'd been dismissed in breach of contract. So I was asked to provide an example of how the conduct
a good example.
paradigm. It is only an example, I accept that, but it is an example.
I thought it was a good example of the point you're trying to make, is how the two systems interact and maybe produce different results.
Yes.
Yes, and it's hard to see how, in the circumstances of this case, where the conduct, what didn't really arise directly out of the employment relationship, it's not something that would have been foreseen in the contract of employment, that the employer would allow someone to take plant and machinery, i.e. a bus, on holiday.
Yes.
One can see that there might be a danger if you employ a purely contractual analysis, that you put things into a straitjacket.
Right. The other example, general example, is that often in employment tribunal cases, there is the employer will have a disciplinary procedure or policy, which may set out in a list of examples of matters that presumptively might amount to gross misconduct, so theft, assault, whatever it might be. But there may be a dispute as to whether or not that disciplinary policy or procedure has been incorporated into the contract of employment. And so it may well be, even if the disciplinary procedure itself provides for an act of assault being something that amounts to misconduct, that may not be an express term of the contract. And yet in those circumstances, that might be another example of conduct which is out with the terms of the contract, upon which a reasonable employer might be reasonably entitled to conclude that the employee had committed an act of misconduct. There may be, for example, perhaps a good modern example is social media, where you might have a disciplinary procedural policy which has not yet reflected the which employees might use social media. If you had, for example, an employee who, give an example in the school's context, who uploaded sexualised or inappropriate content onto his Facebook page, and on that Facebook page he was friends with pupils of the school, there may be no express or implied term of the contract that deals with that specific circumstance. But in my submission, that would be an example of where an employer would be reasonably entitled to conclude that that was conduct, at least in principle, that was capable of amounting to misconduct, justifying dismissal. So unless there's anything else with which I can assist
I thought I heard you say that there were two examples.
Well,
this was the first.
That was perhaps the first example, and I was giving you some examples afterwards of things that weren't in cases, but that
Oh, I see.
examples. I'm
Did
sorry.
you say we'd got Fishman?
Yes, you do have Fishman.
It's simply that it's Mr Justice Phillips who had a lot to do with
it's at tab
the
1.
early stages of this, didn't he?
Yes.
It's tab 1, Authorities 18.
Thank you.
This is perhaps not such a helpful example because it's the other way round.
It's the other way round.
I mean, in the sense that it is not the paradigm example that you were searching for, which is why I didn't immediately take you to it.
Rather sounds as if there isn't a paradigm example, but there are examples.
But there are certainly examples, and I think perhaps the best, and I emphasise the best that we could come up with in the time available was the Western Recovery Services as the example of the right way round as opposed to the wrong way round. But the relevant passages, this is a case in which the teacher was dismissed for refusing to comply with an instruction to teach English for most of the week. One can get the facts actually from the head note on page 690. She'd been engaged to be in charge of a resources centre and then was subsequently asked to teach 18 periods a week of English rather than focus on the resource centre. It was dismissed for gross misconduct. The Employment Tribunal's analysis is at page 693, letters G to H. The Industrial Tribunal took the view there was no justification for the local authority to dismiss the employee for misconduct. They took the view that she was being required to do work which was different from that which she'd been employed to do, and that whilst there's flexibility in the contract of employment of a teacher, and teachers can be required to help out and do teaching other than that for which they're particularly engaged, the post which the employee had been offered and accepted was a unique post which expressly excluded general classroom teaching. They found she was well within her rights and behaved reasonably. And the analysis from Justice Phillips, as he then was, is on page 695, letters C to E. And he says, in truth, we think that the Industrial Tribunal perhaps paid too much attention to the contractual position. The jurisdiction based on paragraph 6.8 of Schedule 1 to the Trade Union and Labour Relations Act 1974 has not got much to do with contractual rights and duties. Many dismissals are unfair, although the employer is contractually entitled to dismiss the employee. Contrariwise, some dismissals are not unfair, although the employer was not contractually entitled to dismiss the employee. Although contractual rights and duties are not irrelevant to the question posed by paragraph 6.8, they are not of the first importance. The question which the Industrial Tribunal had to answer in this case was whether the local authority could satisfy them that in the circumstances having regard to equity and the substantial merits of the case, they acted reasonably in treating the employee's refusal to teach English for 18 periods as a sufficient reason for dismissing her. So, in my submission, that paragraph accords entirely with the way that I put the case to you this morning, that it's relative but not determinative. Sorry, relevant but not determinative. I'm very conscious that we haven't provided you with the full account of the case law in this respect, because we were proceeding on the basis of a concession. It's entirely a matter for you, but if you thought it appropriate, position to make sure that we haven't missed any other examples of this arising, and if we were to find any further examples, to provide those to the court.
Well, that would be helpful, but of course you must first provide them to Mr.
Yes.
Palmer.
Well, Melanie, that goes without saying,
Yeah.
but as I say, I am very conscious that the way that this matter has come up is not, we haven't canvassed the entire field in the way that we would ordinarily expect to. So I just say that in case we find some other helpful or indeed unhelpful examples of the genre, and we can
Yes,
provide
either way.
Well, of course. My lords, unless I can be of any further assistance. Those are my submissions.
No, thank you very much indeed. I'm sorry, I don't know how to pronounce your name, Miss
My lady, it's Miss Bickeregi.
Mr. Oh, it's pronounced how it's written. Yes. Well, Miss Bickeregi, is there anything you'd like to add to what your learned leader has said?
No, thank you very much.
Yes, Mr. Palmer.
My lady, I'm grateful. My lady, my lords, if I can deal first with the urging that has been made to this court in terms of subsequent legislation and regulations which deal with different scenarios, that of itself a precautionary note should be taken, insofar as, of course, those regulations are not applicable to the circumstances of disclosure of enhanced potential risk in the context of safeguarding. And the duty is sufficiently wide to merit a description by Lord Justice Floyd of potentially representing a spectrum. And indeed, in the absence of any prescription as to what the parameters are, of course, we say it is important that where the duty is engaged, that it is engaged in a way which relates to the facts. A question was raised, and unfortunately my note doesn't record which of my lordships made it, be it Lord Carnworth or Lord Hodge, which was, in terms of conduct taking the form of omission, when does an obligation to act arise? And we say, in the context of this duty, then it reinforces the importance of personal judgment in terms of the person who is under a duty to form a view as to whether, on a reasonable basis, circumstances militate in favour of a time arising at which action should, or a time has arisen in which action should take place. That of itself, we say, links to the implied term of trust and confidence, which is implied into the contract, effectively to make the contract workable. And one can see circumstances where an employee should act in good faith in order to act, as opposed to omit to act. In our submission, this examination is simply lacking from the findings of the disciplinary panel.
I mean, you're not suggesting it's a purely subjective judgment for your client, are you? I mean, surely she must also put herself in the position of the governors and say, well, would they want to know about this?
My lord, I accept it must effectively be a mixed assessment, subjective in so much as an apprehension of the facts, but objective in terms of assessing what the requirement of the safeguarding obligation is in the context of the governing body and its relevant policies and procedures, and the extent as to which there is the potential of enhanced risk. So I don't seek to accord subjectivity as the sole guide. That subjectivity has to be tempered by a degree of objectivity.
What was said was the school needed to know about it so they could manage it and discuss with her the arrangements needed to do that. Wasn't that a reasonable view?
To the extent that the person who is under the duty is able to identify that the facts have themselves caused the duty to be engaged, my Lord, coming back to the soft end, if I can describe it, of Lord Justice Floyd's spectrum of the distant relative.
But I mean, that's so far from this case. We've got an experienced teacher who finds herself in a very difficult position where she has to make a decision and she sensibly gets advice from people. But surely one of the things she would want to do, I mean, she's obviously worked with governors before, is to think, well, what would they want to do? Isn't that a sort of perfectly natural approach?
I accept, my Lord, that would have to be one of the factors that should determine whether or not the duty is.
Why does that raise any issue of law? That's what I find. The employment, I can see it could easily have gone the other way in the employment tribunal, but it didn't. And here we are, 8 years later, discussing it in the Supreme Court. Anyway, sorry. I'm still trying to see what is the point of law which we're being asked to decide. On your case, I mean, my lady has posited a possible point of law, which is quite difficult, but what is the point of law that you're asking us to decide?
My Lord, what we say in this case is that a duty has been posited as being obvious by the employment tribunal interpreting the actions of the disciplinary panel. It has pointed to that obligation being sufficiently obvious that breach of it with the added element of a failure to recognise its obviousness and importance magnifies the level of misconduct. But it hasn't explained in terms of either the interpretation of the disciplinary panel's sense as to what constituted the duty, or indeed the employment tribunal's positing of the very duty, quite what the parameters are. And we say the point of law there is that absent those parameters, any dismissal can only fall to be unreasonable. For those reasons, my lady and my lord, we invite you to allow the appeal and to quash the finding that this dismissal was substantively fair and the related findings that there should be a reduction by way of procedural unfairness and contributory fault. My lady, unless I can assist you and your lordships further, those are my submissions.
I think not, Mr. Palmer. Thank you very much indeed. Well, we're grateful to you all for your arguments, both oral and in writing. Rest assured that we have read all your arguments and we will go away and consider what the answer might be and let you know in the usual course of events. Court is now adjourned.